Commercially viable doesn't mean what you think. A lawyer reads YouTube's new terms of service. Hello and welcome to another episode of Virtual Legality. I'm Richard Hoeg, the managing member of the Hoeg Law business law firm of Northville, Michigan. And today we're going to get right into it because this story actually popped over the weekend and I was asked about it a number of times and I saw a number of articles on it. It is about YouTube's new terms of service. Now, if you're not on YouTube regularly or if you're not providing content to YouTube like I am, you probably haven't seen that there's a little window that pops up when you access YouTube that says, hey, we're changing our terms of service as of, I believe it's December 10th. And if you are going to use YouTube after that point in time, you need to know what those terms of service are. Now, this happens all the time. This is what tech companies do. This is what companies do. They change their terms of service, and they did the right thing at YouTube. They notified you of it a month in advance and said, hey, this is what's going to happen. But what they weren't expecting, I wouldn't think, is that a bunch of news stories popped over the weekend that called out a very particular point in these new terms and conditions, and it's about commercial viability. And YouTube has reserved the right, essentially, to terminate the service if it deems that provision of the service to a person is no longer, quote-unquote, commercially viable. Now, we're going to take a look at the new terms of service. I love diving into these things. I love talking about them. If you're familiar with virtual legality, you know that about me. And we're going to talk about that particular issue. We're also going to talk about why it doesn't actually change YouTube's rights as they stand today, or even as they stand in the rest of the document that they're providing in the other terms of service. So while I think there's something to talk about here, and while I find it interesting that a number of people have jumped on this, they've made YouTube videos, they've done other things about this point, it isn't actually fundamentally changing YouTube's powers here. And so I think it's important to kind of dive into why that might be. So I've pulled up the Google page here of all these references. YouTube can terminate channels that it deems aren't commercially viable. YouTube can now delete accounts that aren't commercially viable, et cetera, et cetera. And these are on major sites. That's not exactly, these headlines aren't exactly what the provision says, which is why you are watching Virtual Legality, is to talk about what the provision actually says. So let's take a look at the actual new terms of service as of December 10th, 2019. Now, Google and YouTube were nice enough here to kind of put in highlights as to what they think is significant that they changed. You'll note here when they get to account suspensions and terminations, which is the section that we're going to talk about with some focus today, they didn't actually reference this thing about commercial viability. They didn't deem it to be a significant change. And I think if you're the lawyers at YouTube or you're the lawyers at Google, you think of it as saying, oh, well, we always had the right to change the service for any reason and for no reason. So this isn't that big of a deal other than the fact that we are signposting that this is now something that you should be aware of that we can do, which we could do anyway. So they think of it as a good thing, right? This entire set of terms and conditions was basically designed around simplifying, making friendlier, hail friend versions of the terms of service, which we have talked about in Virtual Legality to some extent when Twitch changed their terms of service, when Facebook changed their terms of service. And you can see it here. One of the things that I do as a lawyer when I'm looking at changes in contracts, when I'm looking at changes in terms of service, is to look and make a red line of what was actually changed so that I can reflect on what was changed. But when a company like Google or YouTube changes the entire kind of functionality of how their rules are to be read, when they take something that was somewhat legalese and they make it into something that is not, you get a red line that looks like this with very, very significant changes, only the smallest amount of language that even survived entirely. That doesn't mean the substance changed entirely. That means the way they spoke about the substance changed entirely. So when I went to do this red line this morning to kind of have this video and to talk about it with you, I looked at it and said, well, that's not going to work because they changed the formatting, they changed the entire concepts of how they were talking about these things, which is fine, but it means that we have to look at it kind of holistically. So going back to what they're actually proposing for early December, we see here that it's the kind of new framework for terms and conditions, very friendly. Thank you for using the YouTube platform and the products, services, and features which we make available to you as part of the platform. Our service, the service allows you to discover, watch, and share videos and other content, provides a forum for people to connect, inform, and inspire others across the globe, and acts as a distribution platform for original content creators and advertisers, large and small. See, we've talked about this in previous videos, but this is the kind of thrust of modern internet-based terms and conditions. It has kind of a marketing spiel at the top of them. This isn't obviously legally effective. This doesn't do anything regarding your legal rights. your legal obligations, their rights, their obligations. It's just designed to say, hey, so you found yourself on the terms of service page. Let's talk about our product a little bit. And they continue on with, you can also read all about enjoying content on other devices, et cetera, et cetera. They then go on to say, your service provider is now Google LLC and includes all the affiliates in the Alphabet corporate group. That's Google and the rest. These are all applicable terms. They incorporate by cross-reference their community guidelines, their policy, safety, and copyright policies, their advertising policies. You'll see another couple links here. That's all normal, and this is included in small part in the current terms of service. You then see who may use the service. You must be at least 13 years old to use the service. This goes back to a previous video that we did on YouTube dealing with COPA issues and dealing with various international and state agencies that want to enforce various rules about children accessing YouTube. So you say up front, if you're YouTube, you're not allowed to access this unless you're 13. Now, they can look at their metrics. One of the reasons they got in trouble with the FTC is that they know that people that aren't 13 access the service. So they say that you can't unless you're 13. They also say if you're under 18, the parent or guardian has to approve of it, which reading these together would mean that if you're between 13 and 18, you can do it with a parent's permission. And if you're under 13, you can't at all. But that's obviously not the way the world works. So if you're watching it with a parent under 13, technically you're probably in violation of the terms of service at YouTube, but this isn't something that's going to pop up in terms of legal liability or otherwise. They also make clear that if you're an entity that's using it, that your entity is authorized to act on your behalf and that you are authorized to sign things on behalf of the entity. And then they talk about content. So this is the content description. If we go to the other terms of service, which we'll look at in just a second, you'll see here that this is a lot less legalese. This is designed to be easier to read. And honestly, in reading this before doing this video this morning, I think that they did a good job. I think that these rules are better than Twitch's. They're better than Facebook's in terms of describing what it is that they do, what rights and obligations that they have and that you have, and that this is better than the current version of the terms of service. They say your content includes everything you might imagine when you upload things to YouTube or when you write comments to other YouTubers' content. Content is the responsibility of the person or entity that provides it to the service. Notice this next line. YouTube is under no obligation to host or serve content. You'll see this repeated here and there throughout these terms of service. But in essence, YouTube is a free service. You can go, you can sign up, you can upload a video. YouTube allows you to use its bandwidth, its servers. You can do all of that. It's a free service, and like most free services on the internet, they reserve the right to not perform the service for you because they're not collecting money directly from you. So YouTube is under no obligation to host or serve content. They can cancel themselves completely. They can cancel any given account. They can cancel any given state's accounts, and that has always been the case. And I say that because I'm looking at the terms of service now, and I was doing it in preparation for this video, and I spotted here, looking through the current terms of service, which I, of course, read and looked through before I even started doing virtual legality or doing most of the YouTube videos that I did, says at the bottom, general use of the service, YouTube reserves the right to discontinue any aspect of the service at any time. Any aspect means, from a lawyer's perspective, they don't have to close down the entire shop. They can cancel any given feature or function or account or state's accounts or country's accounts as they determine in their discretion. And that's part of the terms of service here. And that's not unusual for a free service. You get to here where we're talking about account termination policy. And this is one of those areas where they're trying to clean up in these new terms. Because this termination policy is limited only to breaches, right? It says YouTube will terminate a user's access to the service if, under appropriate circumstances, the user is determined to be a repeat infringer. Infringer meaning copyrights. YouTube reserves the right to decide whether content violates these terms of services for reasons other than copyright infringement, such as but not limited to pornography, obscenity, or excessive length. YouTube may at any time, without prior notice and in its sole discretion, remove such content or terminate a user's account for submitting such material in violation of these terms of services. So they have those rights. And somebody reading these, it's not a lawyer, or is just looking at these and saying, okay, I understand that that's when you can get your account terminated, could look at this and say those are the only reasons that YouTube could terminate its account. But that's not how these terms of services read, and that's not what would be normal for a terms document like this. They reserve the right to discontinue any aspect of the service at any time. But this is all very legalese, and it's not terribly easy to read. So I think it's to their credit that they tried to make it easier to understand by kind of highlighting the different areas that they can actually remove content and say it's essentially total authority. YouTube is under no obligation to host or serve content. Changes to the service. YouTube is constantly changing and improving the service. We may also need to alter or discontinue the service or any part of it in order to make performance or security improvements, change functionality and features, make changes to comply with law, or prevent illegal activities on or abuse of our systems. We may need to alter or discontinue the service in order to do those things. These changes may affect all users, some users, or even an individual user. So note this language here. They are reserving the right to change their service only to attack, to limit, to modify, to change the functionality afforded to one single YouTube user, which means if you're reading these all together, they can terminate you for any reason that they want, and they always have been able to, but they're trying to be clearer about it up front. Now, you don't have to like the current set of terms and conditions. You don't have to like the current way YouTube operates. There are many issues that I have with what YouTube does, with what Google does. But when we're talking about what happens in these new terms of service, it does a disservice to people who are watching your videos or reading your articles to highlight these changes and suggest they are fundamentally different from what YouTube has the authority to do right now. They've always had this authority. They are making it more explicit. And I think if we want clearer terms and conditions, if we don't want the ball hidden quite as much as it is currently in the terms of service for YouTube, then we need to start advocating and espousing clearer terms and conditions. Hey, at least I know what I'm getting into with YouTube now, when they always had this right and they were just kind of hiding the language in a way maybe only Hoeg and Virtual Legality could fully understand. They are trying to be more open and honest with what powers they have, even if those powers aren't significantly different. Now, there are a couple of areas that I don't think are necessarily different here in terms of their permissions and restrictions, but I think are worth highlighting because they don't really appear as analogous in any of the current terms. They say here, the following restrictions apply to your use of the service. You are not allowed to. Normal things. You're not allowed to sell access to the service. We're YouTube. We sell access. You don't sell access. You can't circumvent our security features. You can't use bots to do various things on our service. You can't harvest information from us. You can't distribute unsolicited promotional or commercial content or other unwanted or mass solicitations. All right, still perfectly normal. Now, you can't cause or encourage any inaccurate measurements of genuine user engagement with the service. Okay. You can't go and try to fake popularity on YouTube. That's a violation of the terms of service, including by paying people or providing them with incentives to increase a video's likes, dislikes, or to increase a channel's subscribers, or otherwise manipulate metrics in any manner. Now, I look at this as a lawyer and say, okay, you drafted this way too broadly, right? Because this technically includes advertisement, right? What exactly is advertising your YouTube channel unless it's trying to get an increase in your channel's subscribers? Is that a manipulation of metrics? Probably not. It's probably not intended to be that. And I don't want anybody to flip out and now make a series of YouTube videos based on what Hoeg Law and Virtual Legality said when highlighting these things. But even Google and YouTube, that has all these highly priced lawyers, has in-house counsel, has outside counsel, can still draft language that is probably too broad. And looking at this, I think this is one of those areas. Obviously, we understand what they are trying to target. They're trying to target just buying people to subscribe so your number looks higher and hopefully snowballs into higher and higher retention, and otherwise tells YouTube that they should get you on their recommended algorithm or whatever. But this probably includes what we would consider standard, hey, come check this out, this is really cool, type advertising, even if that payment isn't made directly to the people that would otherwise be coming to your channel. So I think this could be streamlined. I think this could be drafted better. I don't think YouTube has any intent to otherwise limit people's ability to advertise their YouTube channels, but you can see how that language could be read to do so. The next one that I wanted to highlight: use the service to view or listen to content other than for personal non-commercial use. That's pretty normal and does connect with some of the stuff that's in their current terms and conditions. But the parenthetical is not as normal. For example, you may not publicly screen videos or stream music from the service. Now, YouTube's always kind of had this somewhat public use adjacent policy in their terms of service that says you're technically not supposed to do that. This is a little bit written more boldly, more clearly, to say, hey, if you want to play that YouTube video for your college class, maybe you aren't allowed to do that. Now, like in every other instance, it's a little bit difficult to see exactly how this would be enforced on the ground, and certainly what it's really aimed at It's really aimed at purely commercial uses of their YouTube video software. You can see in the facts that they have in various other places in their terms and conditions on their website that they're really trying to target other sites that just mirror YouTube, that are shadow YouTube, grab all the videos, and then otherwise sell ads for finding those videos on that site. They're really aimed at that. But they're also trying to appease certain of their license holders, folks that put up music videos and things on the understanding that you'll be watching it at your computer, not that you will be broadcasting it at the club. And so they are trying to get in front of these various things. But this is a specific, different way of saying some of the stuff that's in the current terms and conditions. And I think it is, again, to YouTube's credit that they are being open and honest with what these things are. This is a very short terms of service document. This is something that everybody that regularly engages with YouTube should read and should understand. But they are kind of making small changes on the margins to what is happening. Next, we have the description of your content. And this is where people that make YouTube videos, that have YouTube channels, are probably the most interested. It says if you have a YouTube channel, you may be able to upload content to the service. You may use your content to promote your business or artistic enterprise. If you choose to upload content, you must not submit to the service any content that does not comply with this agreement, including our community guidelines and everything else that we've incorporated by reference, or the law. For example, the content you submit must not include third-party intellectual property, such as copyrighted material, unless you have permission from that party or are otherwise legally entitled to do so. That's where you capture kind of fair use concepts and other things. You are legally responsible for the content you submit to the service. We may use automated systems that analyze your content to help detect infringement and abuse, such as spam, malware, and illegal content. There's a specific call out here that doesn't really exist in the same way in the current terms that says, hey, you know we do this, but we reserve the right to essentially run your video as you upload it through a bot system. And if you upload it and it says, hey, limited content for advertisers or copyright blocked or whatever else it might say, then that was done essentially automatedly. And so you can go and you can challenge that. And I've done that on a number of virtual legality episodes based on, I guess, controversial subjects that were flagged by their bot system. And every single review has come back and said, you're fine. But it can get a little annoying, and because they know it can get a little annoying, they specifically call out and say, hey, just so we're clear, this is what we do when you upload a video. You retain ownership rights in your content. However, we do require you to grant certain rights to YouTube and other users of the service, as described below. By providing the content to the service, you grant to YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content in connection with the service and YouTube's business. That's a very normal license. That's exactly what you would need to give to them in order for them to do what they do, which is display your video for others, including for purposes of promoting and redistributing part or all of the service. So that's the part that's maybe a little bit extra that you maybe don't expect. If they really love your video, they can put that video in the latest YouTube commercial that airs during the Super Bowl. And you might expect that just because that's what YouTube is. It's very public. But YouTube explicitly reserves the right to use your video to sell their service. You also grant each other user of the service a worldwide, non-exclusive, royalty-free license to access your content through the service and to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it only as enabled by a feature of the service. So they can use your content as YouTube allows them to do, which ultimately could be significant, especially in the future, if YouTube has various editing and other kind of memifying powers that they could grant to users of their service. That's not really the world that we live in today, but it is part of the license, and it's always been part of the license. The duration exists for as long as the video is up and for now described as a commercially reasonable time after you remove or delete your content. And I think the best way to read that is that when you delete it, it's still on YouTube servers for a time until they're flushed, until they're otherwise fixed up. And you essentially say, yeah, that's fine as long as you delete them on a commercially reasonable time period. You may remove your content from the service at any time. You can also make a copy of your content before removing it. You must remove your content if you no longer have the rights required by these terms. We can remove your content if we believe it may cause harm to YouTube, our users, or third parties. Now, mostly I was looking at this with somewhat skeptical interest, but it appears that this is focused on, despite them having pure authority to change whatever they want in terms of the services and what they host, that this is purely focused on those kinds of videos that you see them getting so much flack over with respect to shootings and other significant mass events where somebody that's putting up a YouTube video is potentially causing harm to others, is potentially causing harm to YouTube, its advertisers, whomever. And YouTube wants to be very explicit here that says, hey, if any of that happens in our discretion, we can start removing things. Now, they've always had the right to remove whatever they want. They've always had the right to say we don't have any obligation to host anything. But we want to be clear here that we can remove it in this specific instance because people are interested in this and because we get all those negative news articles about our service when they happen and we can't remove them fast enough. Account suspension and termination. So we're finally at where all of these videos and all of these articles are talking about. Terminations by you. You may stop using the service at any time. That's good. We don't want YouTube to obligate us to use the service. It's very normal, of course. Follow these instructions to delete the service from your Google account, which involves closing your YouTube channel and removing your data. You also have the option to download a copy of your data first, which is great. Terminations and suspensions by YouTube for cause. Now, this mirrors what we earlier read in the current terms of service. YouTube may suspend or terminate your access, your Google account, or your Google's account's access to all or part of the service if you materially or repeatedly breach this agreement. We were required to do so to comply with a legal requirement or a court order, or we would believe there has been conduct that creates or could create liability or harm to any user, other third party, YouTube, or our affiliates. Now that's very broad, right? We believe there has been conduct that could create harm to YouTube or its affiliates. That includes a lot of stuff. That would include, various social media discussions that could be happening from a content creator that's famous and that looks bad for YouTube or its affiliates. They could cut you off just for that. And when you look at something like that, you say, well, that's pretty broad. It's totally within the rights that they have under the current terms of service. But why do they need this additional language? And again, I think it's designed to avoid the kind of umbrella terms and conditions that have been the norm in legal documentation for as long as I've been a lawyer, and to try to get more explicit about what they might use their powers for. And that's why I think the next provision here is one that has caused people so much pause. YouTube may terminate your access or your Google account's access to all or part of the service if YouTube believes in its sole discretion that provision of the service to you is no longer commercially viable. Now, people have been interpreting this to mean a reflection on the channel's commercial viability. That, okay, you're only making 25 cents a video, and so you're really not commercially viable. YouTube shouldn't be backing you up, and so they're going to cut you off. That's not really what this says. This says almost the opposite. Instead of looking at it from the YouTube channel provider's perspective, you have to look at it from YouTube's perspective. And YouTube has to spend a certain amount of money maintaining servers, upkeeping their services, and providing bandwidth and access to individuals that create this content that have these channels. And so what they're saying is when from YouTube's perspective, that process is no longer commercially viable, then we can cut you off. And we can cut you off under the authority that we otherwise have in these terms of service, under the authority that we otherwise have in our current terms of service, but very expressly and explicitly about the fact that if we don't think we can make money off of you, we can shut you off. And if you're familiar with these contracts, I don't think anybody was really confused about that point, right? YouTube is not a nonprofit. It's not a charity. It makes a lot of money for its parent company. And if there is a relationship that it has that it believes is no longer commercially viable, then it was already going to cut you off. It was already going to cut the services off. And you say, Rick, okay, but we just talked about a provision that says we believe that your content would cause harm to YouTube. That's a loss of money. Harm would be included in that bucket. Why do they need this additional language? And I would offer this. I believe that this was probably drafted in respect of actions and circumstances that are not the fault of the content creator. If you think of the current environment that Google and YouTube finds itself in, that these terms of service were drafted in, you've got various political candidates talking about breaking up various tech companies. You've got the current resident of the White House talking about attacking YouTube, talking about attacking Facebook and various other social media enterprises. You have a lot of saber rattling in various legislatures about what the tech companies do vis-a-vis the First Amendment, vis-a-vis their rights in these terms of service and other like contracts. And so if you are looking at this, I believe the best way to read this is we at YouTube don't know what laws are going to be put in place, what regulations are going to be put in place. We don't know if net neutrality or any of the other things that the FCC is dealing with are going to be put in place, are going to be terminated, are going to be made worse, are going to be made better. And so we have a provision here that says we don't know if the cost of the internet will quadruple, and we have to really look at who we are servicing in the future. But if we do have to do that, we can cut you off. We don't know if the great state of California will pass a law that says we are now suddenly liable for everything that we weren't otherwise liable for, and we could potentially have tens of millions of dollars of exposure if we allow Californians to upload video onto our service. So if that happens and that liability makes it not commercially viable to service you, we need to have the right to terminate you. I do not believe for one little bit that this means we are going to analyze the small YouTube creators. They've already upgraded their requirements to monetize on YouTube, I think, to 1,000 hours of views and it's something like 4,000 hours of views and 1,000 subscribers. I mean, it's not insubstantial to meet that current threshold, and it wouldn't surprise me if they increase that threshold going forward. But even if somebody isn't necessarily making a lot of money on YouTube, it doesn't mean it's non-commercially viable. YouTube has this thing on lock in terms of mass allowance for people to upload videos. People can upload videos well before they're monetized, and Google and YouTube technically aren't making any money from that. But if they determine in the future that the entire YouTube enterprise is non-viable because the US passed a law or because everything is just more expensive and they want to do something else with their server resources, then they can terminate everybody for that. They can terminate one person for that. They can terminate a state or another jurisdiction. But I think people react to this language because it is so bold, it is so bald-faced. I think that is to be applauded from these companies, and I really don't want to dissuade them from saying these kinds of things because I think that is useful for people to have these conversations. But as a corporate attorney, as someone that reads and drafts and negotiates terms of service and terms and conditions documents every day, every week of the year, I think that it's important to look at this as what it is, which is whether or not it's viable for YouTube, not whether or not it's viable for the individual, which it might not be. Virtual legality doesn't pay for a lunch at this point in time, but that's all right because we want to have these talks, we want to have these discussions, and we want to help explore issues that we see out there like this one in social media that I think have a little bit missed the target in the discussions that we've been seeing. Continuing on, they actually have an increased notification requirement. If you recall from the previous terms of service, the ones that are applicable today, they could do anything they wanted without notification. They actually obligate themselves to notify you for the reason of termination or suspension by YouTube, unless, of course, it would cause harm to us. So that's a pretty bald-faced loophole to place in here insofar as if we think it would make us look bad, that's harm to us, so we don't actually have to notify you in that case. That being said, the fact that they have set the default rule for notification rather than the opposite, where the default rule was we don't have to notify, is encouraging and I think should be seen as helpful to people that are on YouTube. Going further, they talk a little bit about software as a service, how the service works, and then they kind of increased the size of their limitation of liability section. This was actually something that was highlighted when they were summarizing their changes. But basically it says they're not going to be liable for basically anything. And while you can read this section, and I've highlighted it here, as very significant in terms of the limitations of liability, for a free service, it's really not that significant. Basically, when you use YouTube, the service is provided as is. It could be faulty. It could do all these bad things, and they're not going to be liable for it. Use it at your own risk. And also, they've deliberately called out, hey, even our errors or mistakes or inaccuracies or viruses or malicious code transmitted through the service, none of that is our fault. So we are going to be not liable for that in a court of law. You say, okay, well, that isn't great, but it is a free service. And just like the commercially viable language, all of this has to be understood in the context of the words on the page here. The contract is always written by the provider of the service to be maximally protective of them. These aren't negotiated on the fly. You can use the service or you can't. They're the contracts of adhesion we've talked about earlier in virtual legality. But at the end of the day, they are only in business if they have the trust of the people that use their service, if they continue to earn that trust. And so while you have these bits of language that say you're not going to sue us for $1 million for loss of profits because we remove your content. You see here, the removal or unavailability of any content is something that they are accepted from liability for. That they're not going to go and do this willy-nilly. They're not going to go and do this attacking people, because once you get a reputation for that, that goodwill, that brand associated with their business is more important than anything that is written here. Because if they lose that mass market appeal, and maybe they're in the process of doing that, you might have your own opinions on that you can leave in the comments to this video, that if they lose that mass market appeal, then the game is over regardless of what these terms of service say. The rest of this language is very similar to what's in the current terms and conditions, but it is easier to read. And again, I'm not necessarily a fan of everything that YouTube does. We have videos on this channel, on this series, that talk about some things that I disagree with from YouTube. I don't think these terms of service, I don't think this update that is going to be live in another month is one of them. And certainly I think the commercial viability discussion has been misinterpreted, has been misunderstood. And I think if you're listening to this, if you're watching this video, go out there and tell the people that are really concerned about this. Either lead them to this video, which is great, happy to have them, happy to have the conversation in the comments to this video, or just discuss with them that this doesn't change the powers that YouTube already had, and that in general, if we want corporations to be more honest with us and how they might exert their powers in the future, we want this language like is proposed in the terms of service update from YouTube, rather than just the blanket language that I highlighted in the current terms of service, which at the end of the day gets them all the powers they are claiming in these new terms anyway. That's been Virtual Legality for today. If you like this video, please like, please subscribe, please share it around with anybody that you might think is interested. Otherwise, if you watch this on YouTube, thank you so much for watching. And if you listen to it in its podcast format, thank you so much for listening. And I will catch you on the very next episode of Virtual Legality. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.